Imagine a high-stakes spy case crumbling not because of a lack of evidence, but due to a legal loophole in a century-old law. That's exactly what happened in a recent case against two men accused of spying for China, leaving many questioning the adequacy of the UK's legal framework in handling modern espionage threats. But here's where it gets controversial. The Attorney General, Lord Hermer, has pointed the finger squarely at outdated legislation, specifically the Official Secrets Act of 1911, for the collapse of the case. This law, he argues, is no longer fit for purpose in today's complex geopolitical landscape. Lord Hermer, the government's chief legal advisor, expressed frustration during his testimony to Parliament's Joint Committee on the National Security Strategy. He stated unequivocally that if the National Security Act, passed in 2023, had been in place at the time of the alleged offences, the trial would have undoubtedly proceeded. The crux of the issue? The Official Secrets Act requires prosecutors to prove that the information shared was useful to an enemy, a term that has become increasingly problematic in modern legal contexts. The collapse case, involving Christopher Cash, a former parliamentary researcher, and Christopher Berry, an academic, highlights the challenges of applying such archaic language to contemporary espionage scenarios. Prosecutors dropped the charges in September, citing the inability to meet the stringent requirements of the 1911 Act. The government's witness, Deputy National Security Advisor Matt Collins, refused to explicitly label China as an active threat to national security during the time of the alleged offences. This refusal, coupled with a Court of Appeal ruling in July 2024 that clarified the law's interpretation, left prosecutors with insufficient grounds to proceed. Collins, however, expressed surprise at the case's collapse, insisting his statements outlined China's threats in line with the government's policy at the time. And this is the part most people miss: the collapse of the case sparked a heated political debate. The Conservatives accused the Labour government of allowing the case to fail to foster closer economic ties with Beijing. Labour, in turn, denied any political interference, emphasizing that the decision was based on legal advice and the constraints of the outdated law. Lord Hermer dismissed allegations of political meddling as baseless and disgraceful, stressing that such interference would violate constitutional principles. Senior Minister Darren Jones echoed this sentiment, defending the independence of the Crown Prosecution Service, CPS, and rejecting claims that the government was kowtowing to China. He contrasted Labour's approach with that of the previous Conservative government, which he criticized for avoiding dialogue with China altogether. Jones argued that maintaining a working relationship with China, while robustly addressing security threats, is the right approach. The case serves as a stark reminder of the need for modern legislation to address evolving national security challenges. While Lord Hermer acknowledged lessons could be learned, he cautioned against labeling the collapse as farcical or a catastrophic failure, noting the significant efforts made by all parties involved. But here's the burning question: is the UK's legal system equipped to handle 21st century espionage, or are we still shackled by the constraints of the past? What do you think? Share your thoughts in the comments below and let's spark a discussion on how we can better safeguard national security in an ever-changing world. Don't forget to sign up for our Politics Essential newsletter, https://www.bbc.co.uk/newsletters/c7hc239, to stay informed on the latest developments in Westminster and beyond.